Hey, good morning, everyone. Welcome. I'm Erica Frank from the Shaw Law Group, and with me is Rashida Hoffman from the California Civil Rights Division. I will get there.
Civil Rights Department, you're close. I know, it's an adjustment.
Okay, so for those of you who don't realize quite yet, the DFPH has been rebranded, so it's going to take us all some time to get used to the new name. California Civil Rights Department.
Yes.
Right?
CRD okay. For short. I'm still getting used to it too, Erica, so you're in good company.
And I noticed on the website today when I was preparing for this morning's debut that there was an announcement on the website as far as, things are being changed and that you are updating posters and brochures and that sort of thing as well to reflect the new name.
That is exactly right. Yeah, we're sort of rolling it out. It is a bit of a process with all the various resources we have and like our existing branding and IT elements. But yes, everything is in motion. So at some point, everything will be converted to our lovely new branding and name.
Awesome. Awesome. All right. Well, without further ado, it looks like the popcorn stopped popping. I always think that these webinars, seeing the attendee numbers start to climb, once the number starts to slow down, then we can roll. Why don't we go ahead and get started?
Rad. Okay. I'm going to hide you because there's just so many windows.
You don't want to look at my face anymore?
Well, I would love to. I wish I could look at all the windows, but it's just too much. I'm just going to put this here, this one over here.
So for some of you that are just joining, welcome. You have not missed out. We're just getting started with retaliation in the workplace, a nice light topic on a Thursday morning. So let me introduce a little Rashida. Rashida is Senior Fair Employment and Housing Counsel in the Education and Outreach Unit of, yes, the Civil Rights Department, formerly DFEH. She is an attorney licensed to practice in California. Prior to joining CRD, is that right? Yes, CRD, I'm getting it. She was Bay Area Regional Director of Advocacy and Root and Rebound, a statewide nonprofit that focuses on the rights of people to reentry. There, she gained particular expertise in the California Fair Chance Act, a law designed to protect people with conviction histories from discrimination in hiring, and we all are very familiar with the Fair Chance Act. She also has considerable appellate experience, having run a post-conviction solo practice for 7 years and served as an associate staff attorney at the First District Appellate Project. She is based out of San Francisco, California, where she was born and raised.
Thank you for this bombastic introduction
and
for emphasizing my SF native roots. I, for some reason, feel like it's so important to put that in there. It's classic San Francisco native stuff. We just can't shut up about being from here.
Yeah, there's me. We all know. Nah, okay. You can keep going.
Okay, if you insist. And I'll leave this to you because I have my own special disclaimer.
You got it. You got it. So just as a reminder to all of you, we are not providing legal advice today. We're actually intending to just provide you a general overview about the topic of retaliation. Should you feel that you need some legal advice after listening to us today, please reach out to your own counsel for your specific situation. And please, please, please consult with counsel before making any changes to your policies, practices, or procedures. That's extremely important because, as you'll realize with our presentation today with retaliation, there's no one size fits all. Rashida and I were just talking briefly before we started. It is a very fact-specific topic, that each issue needs to be analyzed separately. So again, it's really imperative that you reach out to your counsel before making any changes.
Awesome, very good advice. And now for my special CRD disclaimer, reiterating many of the same points, but this presentation is for informational purposes only, does not establish substantive policy or rights, and does not constitute legal advice. Any opinions expressed by Erica or myself do not necessarily reflect the opinions of CRD. So I know that many of you already know this, but I wanted to start by giving some information about CRD's mission. We are California's civil rights agency, and our mission is to protect the people of California from unlawful discrimination in employment, housing, public accommodations, and state-funded and state-administered programs and activities, as well as protecting them from hate, violence, and human trafficking. So we've already mentioned this morning, but as of July, we are now the Civil Rights Department, CRD. We are no longer the Department of Fair Employment and Housing, DFEH. And the name change was really designed to more fully encompass the breadth of what it is that we do, which goes beyond just fair employment and housing matters, as I just said. We have many responsibilities. The first is to do what I'm doing now, which is engage in public outreach and education to provide training and technical assistance to a variety of stakeholders in our great state regarding folks' responsibilities and rights under the law. We also investigate complaints of discrimination as well as cases of broader systemic discrimination. We facilitate mediation and dispute resolution involving civil rights matters. We enforce the laws by prosecuting violations in civil court. And finally, we issue regulations that implement the laws over which we have jurisdiction to provide greater clarity and guidance. One such law, good segue, is the Fair Employment and Housing Act, FEHA, which I'm sure many of you are familiar with. But just for a little review, FEHA went into effect in 1959 and has been consistently updated since. It is codified in the government code, and there's also associated regulations that expand upon the government code. And as the name suggests, it covers both employment and housing. But we are going to be talking about FEHA in the employment context today. So sort of high level, FEHA, let's talk about what FEHA does. FEHA applies to all public employers and private employers with 5 or more employees, okay? And the crux of what it does is it makes it illegal for employers to discriminate against or harass job applicants or employees based on a protected characteristic. So we'll talk about that shortly. It likewise prohibits employers from retaliating against an employee or an applicant if they assert their rights under the law. That's what we're here to talk about today, retaliation. And finally, it requires reasonable accommodations for disabilities and sincerely held religious beliefs. One quick note is that the prohibition on harassment actually applies to private employers of any size, not just private employers with 5 or more employees. So just something to keep in mind. Alrighty, so I just mentioned how FEHA makes it illegal to discriminate against or harass people based on a protected category. What does that mean? A protected category under the law is going to include things like race. That also includes hair texture and style, like I wore my hair curly today, that would be protected. Skin color, ancestry, national origin, religion. I won't read all of these, but I'll just highlight a few. Disability, sex and gender, sexual orientation, as well as gender identity and expression, marital status, and veteran status. And one important sort of asterisk here is that this includes actual or perceived identities. So, you know, I am a multiracial Black woman, but if an employer perceived me as being Latinx and they discriminated against me on that basis, on that specific basis, then that would still be covered under the law, even though their perception is not accurate to reality. Similarly, it includes associational discrimination. So for example, if I, you know, my crew at work that I hang out with are all LGBTQ+ individuals, even if I don't identify that way, if my employer is discriminating against me based on my association with that group, then that would potentially be covered as well. Anything you want to add here, Erica?
No, I think those are great examples because sometimes it's difficult to really describe or wrap a head around what does that perceived mean, and especially with associational discrimination, because that's not something that's talked about a lot, especially at the state DFEH level. So
Absolutely. So if someone is asserting discrimination based on one of those protected categories and their employer does something as a result, that might be an incident of retaliation, which is what we're here to talk about today. So big picture, what is retaliation? The government code states that it is unlawful for an employer to discharge, expel, or otherwise discriminate against any person because they have opposed practices forbidden under FEHA. That's really the crux of what it is we're talking about today. And that might also include filing a complaint, testifying, or assisting in a proceeding or investigation under FEHA. It is also unlawful for an employer to retaliate or otherwise discriminate against a person for requesting an accommodation, whether that's for a religious practice or a disability, regardless of whether the request is actually granted. Okay, so high level, that's what we're talking about when we talk about retaliation. We're going to spend a lot of time today talking over the sort of granular prongs in terms of establishing a claim of retaliation, but this is big picture what it is we're referring to. And just a quick note, oh yeah, go for it, Erica.
no, I was just going to say, oftentimes when we talk about EEO issues, discrimination, harassment, and retaliation, those words can be used very loosely in the workplace. Not every conduct is going to rise to the level of legal retaliation. And those are the things that we're going to be really talking about today so that you can decipher between someone usually using the word retaliation versus using it in the legal sense that could trigger some work on your behalf to address the issue.
Yeah, absolutely right. I mean, I think a lot of these words get used sort of colloquially because people are kind of vaguely familiar with them as concepts without maybe understanding like the full legal context. And so, yeah, I mean, it's important to make that distinction between what someone sort of vaguely might think could constitute retaliation and what actually constitutes retaliation under the law, because those are different sometimes. One quick note is that an employer generally will be held liable for any retaliatory actions made by a supervisor or someone working in a supervisory capacity. Really quickly, I just wanted to talk about the legislative purpose of the retaliation law. I have this lovely quote from a case that states that really the goal here is to prevent employers from deterring employees from asserting good faith discrimination complaints. Essentially, the legislature has recognized that we value employees' rights to sort of assert their rights under the law and make these good faith discrimination complaints when appropriate. And so the legislature, wanted to create sort of avenues for that to happen without any risk of some kind of adverse action or retaliatory action thereafter. Okay, let's talk about the nitty-gritty of how this works. So there are three prongs here in terms of establishing a case of retaliation under FEHA, and all three of these prongs have to be met. They all come with their own sort of individual nuances. As we'll see, they're highly fact-specific. So we'll do our best to provide examples, but it also, it gets really challenging because again, it's going to be very, very fact-specific in each instance. But the three prongs are the person, the employee, was engaged in a protected activity. The employer subjected the employee to an adverse employment action, and there's a relationship or a causal link between that protected activity and the adverse action. So between prong one and prong two, there needs to be some kind of a relationship. Let's talk about prong 1. They were engaged in a protected activity. What does that mean? I think the regs give a bunch of examples of very kind of obvious protected legal activities. So let's just talk through some of those first. One very clear protected legal activity would be filing a complaint with our department or otherwise reaching out to our department for assistance with filing a complaint. Helping someone else file a CRD complaint would also be a protected legal activity. Cooperating with an investigation, whether that's an internal investigation or a CRD investigation. More broadly, opposing employment practices that the person reasonably believes is illegal or are illegal. Participating in an activity that the employer perceives to be in opposition to discrimination, whether or not that's actually the person's intention. So again, we're talking about the employer's perception. And finally, contacting a local organization, maybe a labor org, maybe a local attorney, to discuss possible employment discrimination. So I think, these are all kind of very clearly defined protected legal activities, but there's some nuance. So beyond the sort of obvious ones, what else might constitute a protected legal activity? Standing alone, an employee's unarticulated belief that the employer engaged in some kind of discrimination is not likely to be enough to establish protected conduct or protected legal activity for the purposes of establishing a retaliation case. The important thing here is if there's no evidence that the employer knew that the employee was opposing something based on a reasonable belief that the employer was engaging in discrimination, then the employer isn't on notice, and there's basically no protected legal activity there. So to sort of expand on that, a complaint about a personal grievance or some kind of vague or conclusory remark that doesn't sufficiently put the employer on notice as to what conduct it should investigate, what possibly constitutes discrimination or harassment, is not going to be enough to establish protected conduct. Anything you want to add here, Erica?
So this was an interesting case that came down, oh gosh, I think it was around 2016-ish. I think it was that far back. But anyway, it was a very interesting case involving the employee who had a son who required some medical care. The son, I believe, was diabetic and needed dialysis, if I'm correct in recalling. And the employee was requesting schedule changes, and he was unable to achieve them. And there was a long list of situations that occurred where he had his first supervisor had granted him whatever schedule changes he needed. I believe there was a change in supervisor where that new supervisor didn't necessarily follow the practices of the prior supervisor. And this employee really felt that he was being retaliated against because he needed a schedule change to go assist his disabled son. So this was a very, very fact-specific case that, a lot of us were looking at as, well, wait a second, did the employer actually know? Did the employee actually articulate what was going on? And it turned out that it wasn't because he was needing time to take care of his son. There was nothing in the fact, there was no evidence to suggest, and we'll talk about that causal connection, that his son's medical condition was a reason why they were denying his request for a schedule change. So this is really an important point for all of us to know, and an important part of the case that Rashida here pulled out.
Thank you for that context.
Yeah.
But again, because this is the law and the law is complex, having said all of that, it's important to note that an employee isn't required to use sort of fancy legal terms or buzzwords when demonstrating their opposition to discrimination, okay? the court will find opposing activity if the employee's comments, when read in their totality, show an opposition to discrimination. And the point here is that the law, FEHA, doesn't only protect articulate people or people with sophisticated legal knowledge. All right, the relevant question is not whether the employee made a formal, legally valid accusation, but whether their communication sufficiently conveyed the reasonable concerns that the employer acted unlawfully. So one example, maybe this is a good example, maybe not. Erica, you might have a better one, but if an employee is experiencing sexual harassment, but maybe is not familiar with that term, she's not framing it in that way, but is nonetheless saying, I don't like the way my supervisor is talking to me, it's making me uncomfortable. Maybe she makes a complaint with HR using sort of broader terms, that could potentially constitute a protected legal activity, even though she didn't frame it in terms of like, this is an incident of sexual harassment, this is against the law, this is against FEHA, etc. Erica, do you have anything else?
Yeah, where we see it, a common place where we might see, either perceived retaliation or, for lack of the, guys, it's the emergency alert in Sacramento.
Oh, no.
Yeah, but it just got me off my seat. Okay, so here's a really common example where we have an employee who maybe took a leave of absence, a protected leave, FMLA, CFRA, or even under a FEHA disability reasonable accommodation. They come back and all of a sudden they're being treated differently. Okay, maybe they're being reviewed more closely. Maybe they're being scrutinized more. That could be an example where the employee might come to HR or might say, look, I came back from leave and all of a sudden this is happening. All of a sudden my supervisor is writing me and is telling me I'm not doing things correctly. It was never like that before. It must be because the supervisor's mad that I took X amount of time on leave. We see this frequently with, employees returning from baby bonding leave, whether it's a male or a female, that they all of a sudden are being treated differently. Now, of course, as you're going to hear more as we go through, it's more of whether there actually was a causal connection. Was the performance or scrutinization of their performance because they weren't performing before, and the organization is now, conducting more critical performance reviews of their employees. So again, there's going to be a lot that has to go into determining it, but that would be an example of how we can at least start to see a potential concern, or at least as it's articulated by the employee.
Yeah, thank you for that. And just to go back to the previous slide quickly, in terms of the unarticulated belief and the sort of difference between a personal grievance or a vague and conclusory remark that doesn't sufficiently put the employer on notice, have you encountered stuff like that before? Do you have any examples of something that might not rise to the level of a protected legal activity?
Yeah, so it's not always just like one incident or one a action. You really have to look at the whole issue. So for the example that I gave you before, there are and there have been times where the employer or the supervisor is just irritated that this person was gone for so long because this person, the supervisor had to take on extra work. And in that circumstance, it is very clear that there is some retaliatory conduct. In other cases, although the employee feels that they're being treated differently or they're being quote unquote punished because they took a leave, that's just not the case. The conduct that they're experiencing is what they would have experienced whether or not they went on a leave. So there isn't like this would be an example of X, right? It's always the circumstances surrounding the actual conduct at issue.
Right, and again, always highly fact specific. So
yes.
Helpful to have examples, but at the same time, there's so much nuance here that sometimes I worry about boxing, people in conceptually with my examples, since similar facts might have a different outcome if the specific underlying facts are just a little bit different or the context.
Yeah. And Rashida, I think that's a really good point for all of our listeners to just keep in mind. When we're talking about issues like retaliation, discrimination, again, you've really got to look at the whole issue, and that's why we do workplace investigations. That's why you are required to conduct an investigation into these particular claims, because that's how you're going to be able to piece out what really happened and really make a finding, as to what took place. You may not, make that legal finding as to whether or not it occurred, but at least you're going to have all of your facts and evidence together.
Exactly right. Alrighty, anything else to add before we go to the second prong?
Nope, you're good.
Awesome. All right, for review, my fancy PowerPoint animation, the second prong is that the employer subjected the employee to an adverse employment action. So let's talk about what an adverse employment action might look like. Similarly to the first prong, I think there are some very clear and obvious examples of what might constitute an adverse employment action. So demoting or suspending someone, cutting their hours, failing to hire or consider for hire, certainly terminating them from employment, firing them, which of course includes constructive termination, failing to give equal consideration in making employment decisions, giving someone an unfairly, unwarranted negative evaluation or recommendation, worsening working conditions, including by intensifying harassment, denying other benefits of employment, or otherwise discriminating against the employee. I think those are fairly cut and dry in terms of an adverse employment action. But again, there is nuance here, and things are not always cut and dry in the real world. So the courts have concluded that adverse employment actions also include the entire spectrum of employment actions reasonably likely to adversely and materially affect an employee's job performance or their opportunity for advancement in their career. And so this is probably not going to include, I love this quote, mere offensive utterances, or even a pattern of social slights by either the employer or co-employees. So I remember there's a case, I don't have the site in front of me, but there was a case where someone didn't get invited out to lunch by their boss, and they felt that this was, an adverse employment action that was materially affecting them. And the court disagreed and basically categorized that as like a social slight rather than an adverse or material action. Okay. But of course, it might include patterns of acts that, while individually wouldn't constitute discrimination or retaliation, might when they're taken as a whole. All right, so that's a really important point. And as we sort of keep reflecting throughout this presentation, these kind of concepts need to be interpreted liberally and with a reasonable appreciation of the realities of the workplace. So when this sort of factual investigation or fact finding is happening, you have to really consider the context, the reality of that particular workplace, and the setting. So those are all important aspects when figuring out what constitutes an adverse employment action. Anything else you want to expand on there, Erica?
No, I think as we move through, some of this will come to light a little bit more.
Fantastic. Oh, we're already moving to the third prong.
Oh. All right, so let's go back.
Let's talk about adverse actions. Do you have any examples of like circumstance where a pattern of employer conduct might rise to the level of an adverse employment action, even though individually those like discrete acts might not?
Yeah, so, if you back up one more slide, I like this laundry list of adverse employment actions because these are very common and typically what we see when we start to examine whether legal retaliation actually started to occur. And I particularly like the reference to constructive termination, or formerly constructive discharge. That's where the employer makes the working environment so unbearable that the employee has no choice but to terminate. And oftentimes we will see wrongful termination claims based on this constructive discharge type claim, which again is very fact specific, but it does speak to the of unwelcomed behavior as it relates to, retaliatory conduct. And, if we want to pick up on the example that I gave previously, where we had an employee who was out on leave and all of a sudden returns, and the supervisor is questioning everything that the employee is doing. The supervisor is no longer inviting the employee to team meetings. If we want to make it more contemporary to the remote workplace, they aren't being invited to the team meetings or the Zoom calls. Perhaps they're being disregarded during team meetings, during Zoom calls. All of that can start to create a challenge and create a situation where the employee is going to begin to feel that they're being retaliated for taking a leave of absence. Now, where we could also see it is if an employee has an ongoing medical condition requiring some form of intermittent leave, meaning that periodically that employee may needs to be out, and that means somebody else is going to need to pick up on their work. That starts to go into performance issues, and that's where we start to see the lines blur, and where we can start to see this continued activity and ask ourselves, is this really legitimate? Or is this tied to the fact that this employee took this intermittent leave? So that oftentimes, frankly, is what we see. Rarely do we see those like cut and dry, you're fired, right? Because you didn't come to work, or, for whatever the case may be. Now, of course, when we start to look at some of the protected characteristics of, and we all know there's quite many protected characteristics, adverse action based on one of those protected characteristics can certainly be a problem too, like the examples that you gave, Rashida, earlier when you started. So, I have to say that rarely is it like a smoking gun. This is one incident. Oftentimes it is reflective of a pattern.
Yeah, exactly. And as we keep hammering home, it's really about like the totality of the circumstances and the particular context of that workplace and the realities of that particular workplace.
Right.
So, something that might be standard in one industry or workplace might be, completely not standard in another. And so it's important to kind of tailor the analysis in that way.
Standard though, but not in violation of the protected characteristics.
Exactly right.
So,
exactly.
Just to kind of level set here. Yeah.
Yeah, I just mean in terms of sort of employment practices, like socially, the sort of things that you're referring to in terms of like team meetings and stuff like that. Sort of what's standard in a workplace might differ. And so my point being that it's important to really look at the facts and look at the normal practices there.
Yeah, and I think what's interesting, this L'Oreal case or the Yanowitz case, 2005, a lot has changed since 2005 as far as what's acceptable, what's not acceptable, workplace norms. And, the example that you provided, and I know what case you were talking about, and I wish I could remember too, where, lunching isn't really, it's kind of that social event and whatnot. Today, that might mean something different, right?
Exactly.
Today, especially where a lot of employers are using lunches and, gatherings for their remote employees to get together and engage, that could actually be a meaningful event that someone may feel they're retaliated against because they weren't invited to for whatever protected class, right? We still have to go through that. So it's very you start to see how things have changed, not only since 2005, but even in the last 2 years.
Yeah, I mean, I think that's really, really a good point. And, to just harken back to my previous point that I was attempting to make, in one workplace setting, these kinds of lunches might be very, very informal and purely social, in which case, that case, might still hold true. But in a different context, maybe these lunches are really more so than rapport building. Maybe they're brainstorming sessions, or maybe they're networking opportunities that could really impact someone's advancement in their career. Then that's sort of a different consideration, right? So again, all highly fact specific here.
Yep.
Okay, turning now to the third prong. We're doing great on time. The third prong, of course, is the causal link, the relationship between the first two prongs, the protected activity and the adverse action. So the law states that retaliation is proven by showing that the employee engaged in the protected activity, their employer was aware of this protected activity, and then the adverse action followed within a reasonably short period of time thereafter. Both direct and circumstantial evidence can be used to show the causal link. And in this context, circumstantial evidence might include factors like the plaintiff's job performance, were they excelling, were they not, the timing, certainly, of events, and how the plaintiff was treated in comparison to their colleagues. Anything you want to say on that before I turn to the burden shifting aspect?
This is really where the rubber meets the road from a legal perspective. And when we're looking at legal retaliation, again, this is why we have to look into any potential claim or claim that somebody was potentially retaliated against. And oftentimes you're going to see, not just retaliation, but you might see some claims of discrimination or even harassment as well.
Once an employee is able to prove this causal link between the protected activity and the adverse employment action, the burden then shifts to the employer to show a legitimate, non-retaliatory reason for that adverse employment action. If the employer is able to do this successfully, then the presumption of retaliation drops out of the picture, and the burden then returns to the employee to essentially prove that the employer is lying, that the employer's justification is a pretext, and that actually what happened was this was retaliation. So there's some burden shifting going on. One important point here is that retaliatory intention has to be at least a substantial or motivating factor in the adverse employment decision, but there can be other factors present. So if someone is discriminated against because of their membership in a protected category and they complain and then they face some kind of retaliation, they're maybe taken off the schedule, the retaliatory intention of the employer has to be really like the crux of the matter. But also it might include other factors, like maybe part of why they wanted to take them off the schedule is because they had missed a couple shifts, or they weren't showing up on time. Like that stuff can sort of be in there in the stew, but the retaliatory intention has to be the primary motivating factor in the adverse employment decision.
Now, you all know how much we emphasize the importance of documentation. This is an example of why it's so important, because it is your word against the employer, against the employee. With the burden shift, the employer really needs to have that evidence to support their claim that there was a legitimate business reason. This was not an adverse retaliatory action for a protected purpose. The performance write-ups were part of a bigger picture that the department was exercising, or because the employee's performance was not stellar before they left, and they are needing to now address some of those shortcomings. So it is very important to have the documentation, whether it's internal supervisor notes, whether it's a memo to the file, whether it's even email correspondence between the employer and the employee. Again, we do have more access now to written correspondence because we are in more of a remote virtual world, but it is very important to make sure that we're documenting the processes and decisions.
Yes, thank you for that, Erica. I think that might be it. Are there any other examples or anything else that we should be sure to touch on either this prong or any of the other prongs before we wrap up?
I don't think so, and we don't have any questions coming through, which is understandable to the extent that, again, we can't be speaking to your specific workplace issues other than to be able to help you flag things that you should oh, maybe I need to look into this further, or maybe we should improve some of our practices to make sure that we aren't in a situation where we can't defend ourselves if in the event that there is an allegation of retaliation. I will say that as we are in this remote hybrid world, we are seeing a lot more, many more issues arise about how people are feeling, whether that means that they are misinterpreting an email or a team chat. It's harder to get folks to collaborate because there isn't that natural tendency of just seeing everybody in the workplace. So that's something that employers need to be mindful about as they're adapting to the new world and as they're training employees and supervisors on how to properly engage with each other in this different workplace out in the ether land of virtual, computer speak, for lack of a better word.
Yeah, I really appreciate you bringing in these sort of modern examples, because as you're pointing out, things are changing. Things have changed pretty significantly in the past couple of years in terms of how we interact with one another at the workplace, in terms of what's considered normalized in the workplace. So I think, retaliation being such a highly fact-specific concept, we'll have to adapt to the new normal that we're all living in.
So interesting, we are getting a couple of questions. Brittany had a great question about, is there a reason an employer could use removing an employee from a meeting? Okay. Now, remember, if there are performance-based reasons that are justified, right, completely unrelated to the protected status, or if we're going to use the example that we have with the employee who went out on a leave, there has to be a reason other than we're just annoyed that this person went on a leave and now they're wanting to come back and we're going to just kind of exclude them because we know they're going to be out on a leave again. No, that's a problem. If it's, we're on a deadline, we have a project that we really want this employee to finish up, that's why we're asking this employee not to attend the meeting, that's going to be justifiable, right? There's a legitimate reason why. Maybe the meeting is only involving certain individuals and that employee doesn't need to be there. There has to be a reason of this employee taking a leave of absence and being away from the workplace. Let's see, what else? Oh, what is considered a relative short time frame? 1 month, 2 months, 1 year? I don't know.
Yeah, that is the question.
I know. And this one always drives employers crazy, rightfully so. We deal with this as, well, how long is too long? When can we tell them no? And again, it's all fact specific. It's all going to be determined on what the issue is. And it's really hard not to blur the lines between a reasonable accommodation request and retaliation and, all of that, because in some respects they do go together, or we do see them together quite frequently, not necessarily that they go together, but we see them together frequently. And that's why, like we said at the beginning of our presentation today, it's so important to evaluate each employee separately and distinct from the others, because each employee is going to have their own story, they're going to have their own circumstances, and they're going to have their own documentation, and it's important to follow the processes for each one. So I wish I could tell you, Gina, what's considered a short time frame, but I can't, because it really just depends on what you're dealing with and what that employee's reality is. I always joke that we have JD behind our names, Rashida, because it means just difficult, because sometimes people get so frustrated, right? Or just depends, because I find myself saying that all of the time, wishing I could provide an answer.
Yeah, absolutely. I know that's lawyering. That's how it goes.
It is. Yeah. But I know that it's really difficult for employers and for supervisors and HR professionals to be able to comply with these rules and facilitate a professional and productive workplace when we have a lot of these unknowns and uncertainties. And in this area, we certainly do. Let's see. Let's see. What if HR says, because the supervisor doesn't want you on the calls? Again, we need to know why. Why does the supervisor not want us on a call? Okay, what is the reason? If it's because the supervisor's annoyed, the employee's been out on a leave, we've got a problem. But if the supervisor has some legitimate reason, and legitimate reason is quite broad as well, I get that, then maybe we don't have a problem. So we really have to get into it. But if this is an issue that's percolating, then it's definitely worth a little inquiry into what's going on and what's on the supervisor's mind and concerns that the supervisor might have. All right, go ahead, Rashida. I think you had some resources to share, right? So these are great. Why don't you talk to us a little bit about them?
Yeah, just really quickly, we have a whole bunch of fantastic resources on our website. As you can see, these ones are still branded DFEH. That will soon change. But just to highlight a few that may be relevant to you all, we have a fact sheet on transgender rights in the workplace that we're actually in the process of updating and expanding upon. We have a fact sheet on the civil rights of LGBTQ+ people, a sexual harassment fact sheet, as well as one on hate violence and civil rights, and many, many others. I did want to note that we do provide equal access to people with disabilities. If anyone needs an accommodation, there's an email address here, and there's also a phone number. And we also offer bilingual services, and we'll provide some translated documents for people with limited English proficiency. Again, if that's something you need to avail yourself of, please contact our communications center and request assistance. There's an email address here as well as some phone numbers. And I think that's all we got. Yes, here's the link to, this is some other information that we have on our website. But it's pretty easy to find all of our fact sheets and stuff. And yes, go ahead, Erica.
To remind folks as well that you are required to have a anti-harassment policy that includes, right, protections or means of sorry, I'm stumbling over my words. Anti-harassment, discrimination, retaliation policy. And of course, this goes with your annual or biannual EEO training that we need to do every 2 years. And again, it's really important for us to all remind our employees and our supervisors about what the expectations are. Of what retaliation is. You know, a lot of us may not understand what it actually means and how it applies to the workplace. So these are all things to keep in mind. The postings and resources that Rashida had displayed are available on the DFEH's website. Some of them are required postings. The transgender rights, for one, is, and you should all have a harassment prevention pamphlet that you provide to new hires. But these are great resources that you could just actually send out to your employees as a reminder, you know, just to keep them in the, you know, keep it on top of mind. They're easy to read. They're intended for employees, not for lawyers. They're broken down in that plain language so everybody can understand. But one of the things that I always like to emphasize is, you know, the importance of reminding our employees about whatever it might be, you know, whether it's about the importance of taking a meal and rest break versus the importance of, hey, we got to remember, these are some of the requirements in the workplace. We are not going to be harassing any individual, and this is what harassment is. This is how it transpires. We're not going to retaliate against anybody. Sometimes we just need a refresher course.
Yes, and really quickly, to your point, Erica, about required displays and things like that, many of these also have an equivalent poster that's sort of like a more digestible and sort of visually striking version of presenting this information. These fact sheets are kind of a little more expanded. There's more citations, there's more information, but the posters are also fantastic resources and should be displayed.
Yep. All right. I think we are just about done. Oh, this is so good. We have to do this one. I mean, you could just like keep talking on and on. Okay, where did it go?
Where should I go?
Nowhere. This is like one of those topics. Okay, Supervisor no longer speaks to the employee in the morning.
Interesting.
Why, right? Why are they no longer speaking to the employee in the morning? Now, if an employee comes to you and says, look, I really feel like I'm being treated differently by my supervisor. The supervisor is no longer greeting me in the morning. He or she is greeting everybody else in the workplace. The supervisor walks by my office and says nothing. And I am feeling like I'm being treated differently. Now, of course, yeah, you are being treated differently if the supervisor is not addressing this employee. There is definitely an issue. The question becomes, does it rise to a level of a legal issue? Now,
Right.
we want to address it because in the workplace, icing somebody out or ignoring somebody is not what we want in the workplace. It's not professional behavior by a supervisor, and certainly not how we want our supervisors to be conducting themselves, especially if one of their direct reports are feeling ignored. But we do need to find out what's going on. Ask the supervisor, hey, I understand that you're giving kudos, or you're walking by and saying hi to everybody in the morning except Jane. Why is that? Now, if we know that there's been some kind of protected activity that Jane has engaged in, or if we know that Jane has been making prior complaints about their supervisor and this is the reaction, then yeah, that's going to start making me a little bit concerned about what's going on and whether or not we have some kind of potential retaliatory conduct happening. But we're not going to know until we look a little bit further into it. So, naturally, and a supervisor no longer speaking to an employee in the morning, that is a red flag, and we want to know why. But are they also no longer speaking to anybody else? Maybe the supervisor needs, has got all sorts of stuff that happens in their lives before they walk through the door, and they need just time to get into their office and take a deep breath and get into the mode. So, like a lot of these issues that we deal with, sometimes there's a bigger story.
Yeah, and I mean, I think it's really, really tricky because the line between what's like a mere social slight, to borrow the verbiage of that one site that I gave, and something that is that's going to rise to the level of an adverse employment action is not always super clear. And again, it's really going to require a lot of fact-finding and factual investigation to figure out what's going on.
So I have to just put a plug in for the Workplace Wake Up with Jen. These are weekly podcasts that Jennifer Shaw produces and publishes, and they are fantastic. They are Jen and her true self, and they are all extremely helpful. They're 15-minute snippets, which is fantastic because that's all you really need. It's good drive time, good, walking your dog in the morning, however you want. But they are released every Wednesday. And Jen really does a good job at bringing up relevant topics, and we certainly try to make sure that they're contemporary as well. So it's a great way to tune in and hear a little bit more from Jen. And I think, let's see, we do have upcoming training. I cannot believe it's almost September of 2022. It's like crazy. Wow. Around this time, I'm in Sacramento and it's really warm here. So around this time is when I start to go, a big cozy sweater kind of sounds nice. And, but that means that the holidays are near, and gosh, I can't even think about that. But we do have more trainings that's happening. There were a couple questions here on investigations. I want to direct you to our intensive workshops on investigations. They're fantastic. They're 3 days, and you really learn everything you need to know about conducting investigations, the drafting reports, the fundamentals. So certainly something for all of you to consider if you have some questions on that, about that. And then, of course, our annual employment law update. Of course, we're in California. There's always new laws. The legislature is winding things down right now. So we'll have a better sense of what the governor is going to be signing and what the governor will sign in the next couple of months. So there's always new and exciting things for us to learn in the area of human resources and employment and labor compliance. So got some help for you there too. And with that, I don't think there's anything more, Rashida, is there? No. It's like so fun to present with you again today, and we look forward to joining us, or for us to do this together again next month.
Absolutely, always such a pleasure, and I hope that this was helpful to folks. I know a lot of this is super fact specific, as we kept saying, but I hope the sort of bigger overview was helpful in orienting you to this issue.
And take care.
Bye, everyone.